Are you wondering what happens to your home and savings if you pass away without a will or a written plan in place? Well, it's a common question, and the answer can significantly affect your loved ones after you're gone. And in today's video, I'm going to answer that question. Hi, I'm Chuck Roulette. I'm an estate and elder law planning attorney licensed to practice law in both Florida and in Minnesota. Now, if you were to pass away without a will or other written plan in place, no one has the legal authority to sign the paperwork required to sell your home or other real estate, to close your accounts, and to otherwise manage your assets. Now, in order to get that authority, they're going to need to go to court to get it. And this process is known as the probate process. So when someone dies without a will and they're having to go into probate, it's known as dying what they call intestate. So in such cases, state laws called intestacy laws actually determine who gets put in charge of your affairs and how your estate is distributed. And here are 5 things you need to know about that. First thing you need to know, the court's going to decide who gets appointed to manage your affairs. Now, this person is known as the personal representative or the executor, and it may or may not be who you would have wanted. Now, in most instances, this will be a family member, as they do have preference under state statute. However, if there are disagreements amongst the family, if there are unique assets or other issues, the probate court may decide to bring in an unrelated party. And even if it is a family member, again, it may not be who you would have wanted. So that's your first takeaway, is the court's going to decide who's in charge. Second thing you need to know is the probate court will determine who inherits everything based on state law. And again, this may not be who or even how you would have wanted your assets to be distributed. So if you're married, your spouse may receive a significant portion of your estate. If you have children, they also may receive a share. If you're unmarried with no children, your estate could go to other family members like parents or siblings. Again, the takeaway here is the court's going to decide based on state law who inherits everything, and it may or may not be who you would have wanted. Third thing you need to be aware of, if you have minor children, the court's going to determine who the long-term guardians are, and your kids will most likely inherit everything outright at the age of 18. Again, this may not align with what you would have wanted. Side note, I also have a file full of stories of children inheriting outright. It's not pretty. So again, third thing to be aware of, if you have minor children, court's going to decide the guardians, and they're most likely going to inherit things at 18. Fourth thing you need to know, you have no say in your legacy. Again, you have no say in charitable donations, gifts to friends, or any specific bequests. So if there's specific items you would want to give to a specific person, unless that's written down somewhere, the court's going to make all of those decisions. So your wishes for your legacy won't be considered, because everything will be distributed again based on state law. Fifth thing you need to be aware of, without your wishes clearly outlined, there's a higher chance of disputes among family members. This can be emotionally and financially draining. The bottom line is that by not having a will in place, it means you lose control over how your estate is handled and distributed. However, by taking the time to create a will, you get to decide who is in charge, to whom everything goes, and any protections or restrictions you would like to put on the transfer of those assets. Now, this is an important point. If you have a will, your family will still need to go through probate. In fact, one of the biggest misconceptions I see in the general public about estate planning is they assume that if they have a will, they do not need to go through probate. And that's not true. A will does not avoid probate. Rather, you should think of your will as a set of written instructions to the probate court judge. So your family will still need to go through probate. However, you get to decide ahead of time who is in charge, where everything goes, and how it gets there. Now, those are huge advantages over doing nothing and letting the court make all of those decisions for you and your family based on state law. Now, if you would like to avoid probate, most of my clients do, it makes things faster, often cheaper, and helps to keep their affairs private, then you may want to consider using a trust. If you would like to learn more about trusts, you can check out some of my other videos, or you can visit our website at roulettelaw.com, or you can join me on my upcoming Masterclass. I'm actually going to be hosting an online masterclass where I reveal some of the strategies I use with my private clients for your will, your trust, your financial powers of attorney, and healthcare documents, as well as strategies for minimizing or even avoiding estate taxes, and how to actually protect the money you leave for your kids in the event they get divorced, they get sued, they have poor money management skills, or something unforeseen happens in their lives. The class is free, and you can register by clicking the link below. And if you found this video helpful, please make sure to like and subscribe, and you'll be notified when I post new videos. And if you have a question, post it in the comments below, and I may answer it in an upcoming video. I hope you found this video helpful, and I look forward to seeing you in either the masterclass or an upcoming video. Be well.